These are the jobs you may not see every day, but just know we're working hard to make Hillsborough County a better place to live, work, and play. Subscribe to our YouTube page for more great county-related videos, only on HTV.
Psst, hey, would you do me a favor? Grab your phone or smart device and open up that camera. Then point it right here at the QR code. Do you have it? I'll wait a second. When you see the link pop up on your screen, give it a tap. You ready? Boom! Welcome to the Hillsborough County official YouTube channel. We've got all sorts of videos here, all about what makes our community such an awesome place. From local events and community highlights to what's in the perfect Cuban sandwich. We've got it all. We're always adding new things, so while you're here, be sure to subscribe and hit that notification bell so you'll never miss a new video. Here's that QR code again, just in case you missed it. Go ahead and check it out. Ooh. This must have fallen out of that video. This really is the perfect Cuban sandwich.
Good morning. Welcome to the September 26, 2023 Land Use Hearing Officer meeting. I'm Pamela Jo Hatley, and I'll be your Land Use Hearing Officer this morning. Before we get started with the meeting, if you're able, please stand for the Pledge of Allegiance. All right, welcome again to the September 26th Land Use Hearing Officer meeting. If you have any noise-making devices on you this morning, would you please silence those at this time? And thank you for that. I will introduce Colleen Marshall with Hillsborough County Development Services Department, and Ms. Marshall will introduce staff, agenda changes, withdrawals, and continuances, and so forth.
Good morning, Colleen Marshall, Development Services. To my right is Carmen Mason of Development Services staff. To my left is Mary Dorman of Hillsborough County Attorney's Office. During the course of the hearing, a number of other staff planners will be presenting their findings for various cases and will be introduced for each item. We have one change to the published agenda on page 5, item F1, variance 230560. The applicant is Project Management Group, LLC, Ruth Lindano. The applicant's here to request a continuance to the November 20th, 2023 Land Use Hearing Officer hearing.
All right, thank you, Ms. Marshall. We'll hear from the applicant at this time. This is variance 23-0560. Is the applicant here? Please come to the microphone. And we need your name and address.
Good morning. Ruth Londono, 1502 West Bush Boulevard. We want to request the continuance for November 20 hearing.
All right. And the basis for the request of the continuance?
We are looking to more information in order to have maybe more issues to handle at that time.
Okay. All right, thank you. Is there anyone here or online who wishes to speak in support or opposition to the continuance of variance 23-0560? All right, I do not hear anyone. All right, we grant the variance, and so variance WS 23-0560 is continued to the November 20, 2023 Land Use Hearing Officer meeting.
Thank you so much. Bye.
Thank you. All right, Ms. Marshall, back to you.
Sure. We have a number of published continuances and withdrawals today. Item A1, Special Use 230219. The applicant is Dean M. and Sonia C. Slavin. This application is out of order to be heard and is being continued to the October 23rd, 2023 Land Use Hearing Officer hearing. Item A2, Special Use 230308. The applicant is Gulfstream Towers, LLC. This application is being continued by staff to the December 19th, 2023 Land Use Hearing Officer hearing. Item A3, variance 230471. The applicant is Melba Merced. This application is out of order to be heard and is being continued to the October 23rd, 2023 Land Use Hearing Officer hearing. Item A4, Special Use 230481. The applicant is David Wright, TSP Companies Incorporated. This application is being continued by staff to the October 23rd, 2023 Land Use Hearing Officer hearing. Item A5, variance 230590. The applicant is Yenny Gerald Perello. This application is out of order to be heard and is being continued to the October 23rd, 2023 Land Use Hearing Officer hearing. Item A6, variance 230594. The applicant is Plato Academy Tampa. This application is continued by staff to the October 23rd, 2023 Land Use Hearing Officer hearing. Item A7, Special Use 230750. The applicant is Tillman Infrastructure. This application is out of order to be heard and is being continued to the October 23rd, 2023 Land Use Hearing Officer hearing. Item A8, Special Use 230746. The applicant is the Diocese of St. Petersburg Incorporated. This application is being continued by the applicant to the October 23rd, 2023 Land Use Hearing Officer hearing. Item A9, variance 230829. The applicant is Tim and Jackie Dixon. This application is out of order to be heard and being continued to the October 23rd, 2023 Land Use Hearing Officer hearing. This concludes the withdrawals and continuances.
All right, thank you. Today's agenda consists of items that require a public hearing before a hearing master. I will conduct a hearing on each agenda item today and will submit a decision within 15 working days after the conclusion of today's public hearings. My decisions will be filed with the clerk of the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure. I will take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil court action. The order of presentation today shall be as follows. First, for variances, Ms. Marshall will call the case. County Development Services will have 5 minutes to present its report and findings. The applicant and applicant's witnesses will have 15 minutes to present the proposal. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal and summation. For special use cases, Ms. Marshall will call the case. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. County Development Services will have 5 minutes to present its report and findings. Planning Commission will have 5 minutes to present its finding of compliance or non-compliance with a comprehensive plan. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will have 5 minutes to present any amended findings or comments, and the applicant will have five minutes for rebuttal and summation. The 15 minutes for proponents and opponents is the total time allotted among them, so if there are a number of persons who wish to speak, the 15 minutes will be distributed among those speakers. If there are a number of speakers who wish to speak on an item today, you can designate a single spokesperson to represent your views. When you come to the microphone to speak, please first state your name and address for the record. The meeting is being recorded, so please speak into the microphone so your testimony can be recorded. When you're finished speaking, please see the clerk to my left here to sign in for the record. Now we'll hear from the County Attorney's Office, who will state the legal requirements for requesting oral argument at the public meeting where the Board of County Commissioners will make a final decision. Well, actually, that's not the case. We'll hear from the County Attorney's Office.
Yes. Mary Dorman from the Hillsborough County Attorney's Office. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. Number 1, the applicant, or number 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the appeals board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the appeals board disregard evidence or testimony that is outside the record made at today's hearing. Any evidence presented to the appeals board that is outside the record created at today's hearing could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the appeals board.
Thank you, Ms. Dorman. All right, all testimony heard today must be under oath. So if you plan to speak today, please stand and raise your hand. And if anyone is online who wishes to speak, also please raise your hand to be sworn in. All right, do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Thank you. All right, Ms. Marshall, when you're ready.
Today's agenda, we have no vested rights, fee waivers, remands, or reconsideration requests, which takes us to Section F, Site Development Variance Requests. Item F2, Variance 230763. The applicant is William Lloyd, RKM Development. The request is a variance to encroach into the wetland setback. Staff findings will be provided by Carla Shelton-Knight.
Good morning, Carla Shelton-Knight with Development Services. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, Section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on July 7th, 2023, is to allow for the placement of an asphalt drive lane, retaining wall, and 4-foot high decorative fence within the 30-foot wetland conservation area setback. Per Land Development Code Section 4.01.07.B.4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests construction of an asphalt drive lane, retaining wall, and 4-foot high decorative fence on top of the retaining wall within the 30-foot wetland conservation area setback. The applicant requests a 25-foot encroachment into the setback to allow for a remaining setback of 5 feet. Staff findings. A wetland setback compensation planting plan has been provided on the site plan dated July 7th, 2023, that provides equivalent square footage of compensation planting to the amount of encroachment.
Thank you. All right, applicant.
Good morning, Madam Hearing Master. Dale Merriman with Merriman Environmental.
Please state your address for the record.
Oh, I'm sorry. 10408 Bloomingdale Avenue, Riverview, 33578. Without repeating what has already been spoken, we are seeking a variance for a wetland setback encroachment. This property is just north of the corner of of US 41 and Sunset Lane. There has been an address assigned, which is 18575 North Highway 41 in Lutz. The property was rezoned July 29th of 22 from ASC 1 to PD. This particular property is a small snippet of the land in the parent tract. We are looking at 2.91 acres out of the parent tract of 68.72 acres of citrus groves and a wetland. And this development, as referenced above, is a convenience store and gas station. And the project property is, in essence, connected to the commercial corner, or will be by way of a connector road to Walgreens. There's a U.S. Postal Service on another corner, McDonald's, and a store right self-storage. Through about 4 to 5 redesigns, we were able to reduce the impacts down to basically 0.22 acres. This wetland, and it should be noted that this was an orange grove, and as you pull out the orange trees, of course, you're going to leave little depressions, and it filled up with water over time, created like a little ditch swale system that went down to the wetland itself. So the current wetland buffer plant composition in the buffer itself is about 95% nuisance exotic vegetation, mainly Brazilian pepper and camphor. So, and the wetland setback encroachment compensation plan, as was noted, has been presented. It is the UMAMs that were approved by Swift Mud and by EPC. EPC's permit was issued October 17th of 22. So we have basically everything in order now. We just need to request that the de minimis impact buffer restoration plan be approved. Thank you, ma'am.
All right. Thank you. Be sure and sign in with the clerk too, Mr. Merriman. Thank you. All right. Is there anyone here or online who wishes to speak in support of this variance request? I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this variance request?
Good morning. Jay Muffley, 102 Fifth Avenue Southeast in Lutz, Florida, 33549. I am speaking for myself and the Lutz Civic Association this morning. I live approximately 3 blocks north of this property. We feel that any loss of wetlands is not good. The wetlands filter the water, support the wildlife, and generally make it beautiful. So we are against any loss of wetlands. I understand they're in a tight corner. So that is all we have to say today, and thank you very much.
Yes, sir. Thank you. Please be sure and sign in with the clerk. Is there anyone else here who wishes to speak in opposition to this variance request? All right, I do not hear anyone. County Development Services, do you have anything further?
Yes, I did just want to point out that EPC has approved the impacts to the wetlands themselves, and that this variance is a request to encroach into the remaining 30-foot setback from the impacted wetland.
Exactly. Thank you very much for clarifying that. All right, applicant, rebuttal and summation. You have 5 minutes.
Basically, as we had said earlier, this is a de minimis impact into the particular buffer, wetland buffer, and most of it was caused by the fact of reducing the amount of wetland impacts for EPC. And as I said, we've gone through 5 iterations to get to this point. And as she had just said, EPC approved it, and we already have the mitigation bank credits available. The listed species survey only showed a couple of gopher tortoise burrows, but nothing else in this area that has cleared orange grove.
All right, and I did have just a quick question for you, just a couple of quick questions.
No, that's fine.
First of all, if you would please state very briefly your professional qualifications.
My qualifications, I have a PhD in natural sciences. I have been in the consulting business for 49 years, long before it was fashionable, and I used to work for the Illinois Department of Conservation.
All right. And in your opinion, then, is this impact to the wetland conservation area setback necessary in order to develop this property? Is there any other way to develop without that impact?
No, there is not. We have tried many different avenues, whether it was reducing buffers down and many items like that, and there really isn't anything else that we can do in this situation.
All right. And I see from your site plan, the area of impact really is, looks like it's related to an access point and drive area around the proposed store, is that correct?
Yes, ma'am. I'll let the engineer address those.
Yes, Ryan McCaffrey with Hamilton Engineering and Surveying, 3409 West Lemon Street, Tampa, Florida, 33609. So the basis of all these iterations is site plans. There's the minimum parking requirements that we needed to meet for the project. And in order to meet the minimum parking requirements, there was no other place for us to put parking besides for behind the building. Another obligation is having the trucks for whether that's fuel, fire, or solid waste in order for them to maneuver the property adequately. The trucks have to go entering from US 41 and then loop around the building to take their exit back to US 41. And then previous iterations of this plan had parking in different locations, but in order to meet the requirements for the septic drain field separation from various structures, we had to relocate the parking that we had where the septic drain field is to the back of the building.
Okay, thank you very much. That addresses my questions.
Thank you.
Thank you. And, all right, then this will close the hearing on variance WS 23-0763.
Next item is item F3, variance 230928. The applicant is Catherine Huffmaster. The request is a variance to encroach into the wetland setback. Staff findings will be provided by Carla Shelton-Knight.
Good morning. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on August 17th, 2023, is to allow for the replacement of an existing pool and screen enclosure with a new pool and screen enclosure within the 30-foot wetland conservation area setback. Per Land Development Code, section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests the construction of a new pool and screen enclosure within the 30-foot wetland conservation area setback. The new pool will replace an existing pool and screen enclosure currently located within the 30-foot wetland conservation area setback, but will encroach closer to the wetland line by approximately 3 feet than the existing pool. The applicant requests a 20-foot encroachment into the setback to allow for a remaining setback of 10 feet. That's all.
All right, thank you. Applicant?
Hello, Michael Huffmaster, 4822 Chapal Boulevard, Lutz, Florida. So as explained, the variance request to replace a pool and cage. This pool and cage has been on the premise since 1990. Both the pool and the cage have been significantly neglected by the previous owners. Leaving a full replacement really is the only option to avoid additional costly home repairs, improve the safety, and modernize the area to better align with the current expectations in the housing market. In all material respect, the dimensions are not changing with regards to distance from the back of the house. It is currently 19 feet from the back of the house. It will remain 19 feet from the back of the house, but we are extending it along the back of the house a little bit further. Because the house is positioned slightly diagonal to the wetland area, as that happens, it does get a little closer. Currently, it is 13 feet from the from the wetland. The new corner would be 10 feet from the wetland. I've explained in the write-up, my neighbor did go through the same process. His corner is 8 feet from the wetland, and the furthest distance is 12 feet from the wetland. So it is aligned with our neighbor that was approved years back. I don't have much more detail than that, but I could take any questions or any other comments.
Okay. No, I think you've explained it well, and I have reviewed your file and I reviewed your variance criteria responses. So just briefly then, as I understand it, you're replacing an existing pool because the existing pool was neglected basically beyond repair or would require costly repairs. Is that correct?
That's correct.
Okay. So you need to replace your pool, and the replacement structure will extend along the rear side of the house, not further toward the wetland necessarily, but along the house, and that'll put it closer into the wetland setback line. Is that correct?
That's correct.
Okay. So it's just a redesign, and it's going to encroach a bit more.
That's correct.
Okay. And I guess from what I understand of your testimony, the way the house is situated on the lot puts it at sort of a diagonal to the wetland conservation setback line.
That's correct, yes.
Okay. And that's what causes this?
Right.
Okay. That explains it then.
Okay.
No more questions for you. Thank you.
All right. Thank
Be
you.
sure and sign in with the clerk.
Sure.
All right. Is there anyone here or online who wishes to speak in support of this variance request? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this variance request? All right, I do not hear anyone. County Development Services, anything further? No, okay. And applicant, just coming back to you, do you have anything further you wish to add?
No, thank you.
That's a no. Okay, thank you. Then that closes the hearing on variance 23-0928.
There are no signed variance requests today, so it takes us to section H, variance requests. Item H1, variance 23-0801. The applicant is Christian F. Amaral Carmo. The request is a variance to accessory structure requirements. Staff findings will be provided by Michelle Montalbano.
Good morning. I'm Michelle Montalbano from Development Services. I'm here to present variance case 230801. The applicant, sorry. Is that okay? Okay. Okay. The applicant is requesting a variance for an accessory structure which occupies a portion of the required rear yard in the RSC6 zoning district. According to LDC section 611-4C3, accessory structures may occupy rear yards provided that they do not take up a maximum of 20% of the required rear yard, with exceptions that do not apply to this case. The applicant requests a 2% increase to the maximum percentage permitted to allow the enclosed pool structure to take up 22% of the required rear yard. In total, 583 square feet of the structure sits in the required rear yard of the allowed 530 square feet. Moving on to our staff findings, as stated by the applicant, the frame shed shown on the survey occupying the rear yard setback to the southeast is being removed. That concludes my report. I'm available if you have any questions.
No questions. Thank you.
Okay, thank you.
All right, applicant.
Good morning. My name is Christiane Carmo, 2530 Ridgetop Way, Valrico, Florida, 33594. 17 years ago, this building was built, and I wasn't in charge of the building permits and anything. I was married at that point, and my ex-husband was in charge. So during a few years back, when I was refinancing the house, it was brought to my attention that the building was larger than what should have been. And I decided that I needed to get it fixed. The situation, Even though I lived there then, I wasn't in charge, so I wasn't very familiar with the process. I did see inspectors coming and going during the construction of the pool, during the construction of the building, but not the whole process. I'm an occupational therapist. I have a condition of use. To use my pool, my specialty is aquatic therapy. I provide aquatic therapy for special needs children. And when it was built, my job was to provide the needs, you know, make it wide enough for the children, make it wide enough for the wheelchairs and walkers. And I wasn't focused on the legalities of the permitting. Again, I had somebody else in charge of that. So it's a very costly process to get it all done. So I couldn't get it done when I found out, which was like 7 years ago. And I kept on planning, and I finally, last year, was able to start the process with the engineering company to draw the plans. And I started in December last year, so I finally got discussed with zoning, and they recommended I apply for a variance based on the size of the building. It is in very good condition, as the plan shows that I submitted to the variance application. I have some pictures here that shows what we do and the width, how it provides the adequate support for the wheelchair and all the ADA requirements for the special needs population. And there is no other place in the area that does this work. And even though nobody has ever complained, my neighbors don't complain, it doesn't encroach in their space, it's just within my area. I feel like I need to make this right, even though nobody is complaining about it. So should I just pass it on to?
Okay, in just a moment. Yes, and you can submit those photographs to the record, and I will see them. And so, from what I understand, then, this is a building that has been in existence on the property for 17 years. Is that correct?
Yes.
And I understand what you use the building for. And I believe you said the building has to be large enough to accommodate your clients' wheelchairs and so forth. Is that correct?
Yeah, it is correct. It could have been smaller if I had known that I had to be, but it's very adequate for what I do.
Okay, so you designed the building so that it would
yes.
Be usable for your
for
purpose.
That purpose.
Okay. And are you changing the building at this time?
Not at all.
Okay, you're just seeking the variance now to correct the situation. Is that correct?
Yes.
All right, I understand. All right, no other questions for you. And you can submit those to the clerk and when you sign in. Thank you. All right, is there anyone here or online who wishes to speak in support of this application? Go ahead.
Hello, my name is Amanda Lyon, and my address is 1022 Sonia Lane, Brandon, Florida, 33511. I am here today to support Ms. Como's variance request. The reason is because I am a parent of a daughter with cerebral palsy, and she has had aquatic therapy services at this particular location for 7 years. It is the only location within an hour's drive to receive these services, and they have been integral in her development and continued progress. And so I just wanted to say that this should be allowed. I think that by her coming forth for forgiveness for this, and the fact that this particular building has been there for 17 years should speak volumes, and also it supports our community in a very important way. Thank you.
All right, thank you very much. Is there anyone else who wishes to speak in support of this application? All right, don't hear anyone. Is there anyone here who wishes to speak, anyone here or online who wishes to speak in opposition to this variance request? All right, I do not hear anyone. Development Services, anything further? No. Okay, thank you. Applicant, did you have anything further? That was a no. All right, thank you. This will close the hearing on variance 23-0801.
The next item is item H2, variance 23-0807. The applicant is Felix Ibargolan Correa. The request is a variance to lot development standards and fence requirements. Staff findings will be provided by Chris Granlenard.
Good morning. Chris Granlenard, Development Services. Here to present variance 23-0807. The applicant is requesting a setback variance to accommodate an existing room addition for a single-family home on a corner lot zoned RSC 9. Additionally, the applicant is requesting a height variance for an existing fence. The variances, the room addition, per LDC section 6.01.01, a minimum front yard setback of 20 feet is required in the RSC 9 district. The subject parcel is a corner lot with the required front yards and the project property lines abutting Amundsen Street and Johns Road. The applicant requests a 1.8-foot reduction to the required front yard setback to allow a setback of 18.2 feet from the southeast property line along Johns Road. The existing fence variance, per LDC section 6.07.02.c.1.a, fences over 4 feet in height shall not be allowed within required front yards, except under certain circumstances that do not apply in this case. The applicant requests a 2-foot increase in the permitted fence height to allow a height of 6 feet for an existing fence located on the southeast property line along Johns Road in the front yard, which functions as a side yard. Findings: the existing fence located on the southeast property line along Johns Road is located on the public right-of-way outside of the property line. The applicant has confirmed that the fence will be moved to the property line within the subject property. The subject fence is the subject of a building services notice of violation, which has been placed in the case file for this application. That concludes my staff report. I'll be glad to answer any questions you might have.
Mr. Granlenard, the building code violation is related to the room addition. Is that what you said? Or the?
I have it here.
Okay, and I believe it's in the file too. I also noticed on the aerial there appears to be an accessory dwelling in the backyard. So is the variance related to that at all, or is it an attached?
No, the applicant in his revised survey indicated that he moved it out of the easement. And then there's also a shed to the, towards Johns Road, but he said he removed that as well. I'm sure the applicant will be able to explain that he removed it. That's what he indicated to me.
And this variance then is just for an attached room addition to the house, is that correct?
And the fence.
And the fence, yes.
Yes.
I'm sorry.
Yes, the violation, I have it here.
Okay.
The notice. It's in the record. It says it's for a notice of violation for, what's in the record, if you wanted. Did you want me to?
That's fine. It's in the record. I will see it. Thank you.
Okay, thank you.
All right, applicant.
Feli Ibargoyin.
Hello, I'm Elizabeth Ibargoyin. I'm going to be translating for my dad today.
All right, thank you. And could you please put your address also on the record?
Sure, 6701 Amundsen Street, Tampa, Florida, 33634.
All right. And we need your testimony heard on the record, so when you speak, please get closer to the microphone.
Gotcha.
Thank you. So what I need to hear is what the variance is for, and supporting reasons for it, hardship reasons, that sort of thing.
Gotcha. Okay. So, lo que quieren oír es soportando lo que hablamos. Okay, ¿qué vas a decir? Okay, so for the fence variance, we require it to be 6 feet just because we have a dog, and since our lot is a corner lot and we have 2 front yards technically, our dog plays in that front yard, and we require it for the safety of the pets and of the neighbors. And we have, he has a granddaughter, my niece, she's like 5 years old, who also plays in the backyard, and also for her safety. For the room addition.
Before you move to that, could also, for the fence.
Yes.
I need to make sure that Mr. Correa understands that if the variance is granted, the fence, well, whether it is or not, actually, the fence is off of his property line, and he does need to move it onto his property and out of the public right-of-way. So please make sure, Mr. Correa, if you could confirm on the record, he understands that will be done.
So están diciendo que la cerca que está en la línea, que tú la moviste, dile que entiendes que la cerca tiene que estar movida. Yo le explico ahora que la moviste.
Ya la movimos, está
Dile, I understand.
It's okay.
You understand, thank you.
So regarding the fence, it has been moved to comply with that. So there has been the space left.
Okay. So the room addition to the house, what are you requesting for the variance for the room addition?
So my grandma, she's elderly, and she just had to come live with us. So we only require like 1.8 feet to encroach in the setback that you guys have for her to have her own space, since she is like pretty old and she needs to be taken care of and watched.
Okay. Anything else you wish to state in support of the variance?
Okay. So le dije lo de abuela, le dije lo de la cerca, lo del duque, lo de la niña. ¿Qué más vas a hacer para lo de la adición del cuarto?
De 1.8, eso no.
Ya lo acabo de decir.
Ya. ¿Qué más? Pregunto que si falta algo más, no sé. I don't know.
Nope. Is there anything else you wanted to ask us?
I think you've answered all my questions. Thank you.
Okay.
All right, y'all, both of you, please be sure and sign in. Thank you. All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, do not hear anyone. Development Services, anything further?
No, thank you.
All right, thank you. And applicant, you didn't have anything further, is that correct? No. All right, I heard a no from the applicant. Thank you. All right, that will close the hearing on variance 23-0807.
Next item is item H3, variance 23-0810. The applicant is Michael Forlong. The request is a variance to accessory structure requirements. Staff findings will be provided by Isis Brown.
Good morning, Isis Brown, Hillsborough County Development Services. Case 23, variance 23-810. The applicant is requesting a variance to accommodate a proposed accessory structure that is greater than 15 feet on a property zone RSC 6 per LDC section 6.11.04. B, accessory structures shall not exceed 15 feet in height, except where the principal structure setbacks on the zoning district. Per LDC Section 6.0601, a minimum rear yard setback of 25 feet and a minimum side yard setback of 10 feet is required in the RSC zoning district, RSC 2 zoning district. The applicant requests the following variances. A 10-foot reduction to the required minimum rear yard setback to allow a 15 feet from the property west property line, a 5-foot reduction to the required side yard setback to allow a side yard setback of 5 feet from the south property line, and 1 foot increase in the permitted maximum structure height to allow a height of 16 feet. There were no staff findings, and I'm available for any questions.
Okay, just to clarify, because I think you initially said the property was zoned RSC 6, but it is RSC 2.
Correct. I'm sorry.
Thank you.
Yes, ma'am.
All right, that's it. Applicant, please.
Good morning. Michael Forlong, 1512 South Villarico Road. My request for variance is, as she stated, there was an error in the sales. I did my due diligence to make sure the building qualified. But after they installed the building, it was 8 inches taller than actually 10 inches taller than what the initial plans suggested. So now it breaks the 15-foot limit.
Okay.
Yeah.
And the building, and I did read your application, so I understand it's a metal building, is that correct? Prefab building. And does it have a roof peak? Does it have a?
It does.
Okay, is that why it exceeds the 15 feet?
It's a metal building, and so on the top it has a ridge, and that ridge is actually 4 inches tall. So.
Okay.
And then on top of the ridge of the metal makes it 8 inches above the calculated initial pitch. But I did check initially, and the salesman confirmed that it was 14 feet, 10 inches. But because he was ordering from a local provider and couldn't get supplies, he had to order from a national provider, and they didn't get it didn't transfer.
I see.
Because of the shortage of supplies. So when they said, we can get it faster, we order it from somewhere else. So they ordered it from somebody else, and I guess that was miscommunicated somewhere.
Okay, so the specifications turned out to be a little different than initially was represented?
What we submitted to the county for approval was the actual national one. So it just doesn't specify the height. It just says wall height and then the pitch.
Okay.
It doesn't accommodate for like the ridge and the ridges and stuff that put it over the 15-foot limit.
Okay. All right, I understand. Anything else?
No, that's it.
Okay. Be sure and sign in with the clerk.
Okay.
All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Do not hear anyone. Development Services, anything further? All right, that's a no. And applicant, anything further? No, okay. That will close the hearing on variance 23-0810.
Next item is item H4, variance 23-0845. The applicant is Scott and Kimberly Aldridge. The request is a variance to accessory dwelling requirements. Staff findings will be provided by Carolyn Peddle.
Good morning. Carolyn Peddle, Development Services.
All right, would you make sure the microphone is down? Thank you.
Sorry. Carolyn Peddle, Development Services, variance 23-0845. The applicant requests a 48.7-foot setback reduction to the required rear yard setback to allow for a 1.3-foot setback from the eastern property line for the accessory dwelling structure on the property, which is zoned ASC 1. LDC Section 61102E, accessory dwellings should meet principal building setbacks and shall contribute to the lot building coverage. Total building coverage on the lot shall not exceed district standards. LDC Section 60101, a minimum rear yard setback of 50 feet is required in the ASC 1 district. A building permit has been submitted for the improvements and construction of additions to the main dwelling and mother-in-law suite. That concludes my report. I'm available for any questions.
All right, thank you. No questions for you. All right, applicant.
Ron Label, 3207 Pearson Road, Valrico, Florida, 33596. The variance is for a building that's been there since 1980, and it was converted into a mother-in-law suite, and we're wanting to add another bedroom and a bathroom to it. So in order to do that, we have to ask the approval for the shorter variance for the rear property line of 1.3 feet, because there's an overhang and a storage area that's attached to that building.
Okay. So, sir, you said the building has been in place since 1980. Was it converted into a dwelling unit?
Yes, ma'am. It used to be a garage.
When was it converted?
That I don't know. We moved here in 2016.
Okay. All right. And what is the size of it?
The current size is 587 square feet.
All right. And you're expanding it?
It's gonna come out to 897 square feet when we add the addition.
Okay. Is there any way to expand it without encroaching into the setback?
No, ma'am. Where it sits, the property line is right behind it, right behind the house.
Mm-hmm. All right. And then the reason you're expanding it again?
For another bathroom and a bedroom.
Okay.
For the mother-in-law suite.
Okay. And is there a bathroom and bedroom in the?
There is currently one, yes.
Okay. So you're expanding it to
Yeah,
two
to
bedrooms?
Yes.
And a bath, 2 baths?
Yes, ma'am.
Okay. And you live there on the primary dwelling?
Yes, ma'am.
Okay. Okay, anything further?
No, ma'am.
All right. All right, please sign in with the clerk's
Yes, ma'am.
office. All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, do not hear anyone. Development Services, anything further?
No, thank you.
No, thank you. Applicant, anything further?
No, ma'am.
No, okay. That closes the hearing on variance 23-0845.
Next item is item H5, variance 230870. The applicant is Stephen and Mary Beth Autry. The request is a variance to lot development standards. Staff findings will be provided by Jaron Fallen.
Good morning. Jared Fallon with Development Services. This is a variance request to allow the reduction of a side yard setback in order to accommodate a proposed elevator addition to a single-family home for the property located at 6716 Surfside Boulevard. The current side yard setback requirement is 10 feet, which is dictated by the current PD zoning district. The request is to reduce the setback from 10 feet to 8 feet, which would give the property owners enough space to construct the elevator along the side of the home. This variance would also address the encroachment of the existing home, which lies 9.5 feet from the property line. I'm happy to answer any questions.
All right, thank you. I have no questions.
Thank you.
All right, applicant?
Good morning. My name is Miles Lagarde. I actually am the applicant for Mr. and Mrs. Autry. I wanted to just take a minute and give you a quick rundown of what we're doing, and then Mr. Autry would like to speak.
Okay, and we need your address on the record too, please.
So my address for my company is 240 Apollo Beach Boulevard in Apollo Beach, Florida. I'm a licensed general contractor, and I am actually applying for this variance for Dr. and Mrs. Autry. The Autrys purchased this home in June of this year. Their intention is to make this their retirement and permanent residence. Mrs. Autry has recently suffered some significant injuries due to a fall and will be in a walker for the foreseeable future. When I'm done, Dr. Autry can speak to the significance of the injury. When the request of the elevator came about, I was given a survey that was done prior to them purchasing the home. And as Jared had spoke to you, the survey shows that the existing house is at a 9'6" setback. It was with just a reasonable deduction that it was probably going to be an 8 or a 7-foot setback. When I called zoning, that's when I was told that it was actually a 10-foot setback and that we were going to have to file for the variance. What we are requesting is a 2-foot variance, which would allow an 8-foot setback. We believe that we have met all 6 of the criteria that you are requesting. The existing footprint of the house supports the elevator in this exact location. It will, and I have some pictures I would like to submit to you, it will allow the both economically and design-wise, there is a spot that the house was actually almost designed for. We'll be taking out a door and 2 windows. The elevator shaft will go there, and again, we're only going to be sticking out 18 inches past the existing structure. We have support from neighbors on both sides, actually on the north side of the property. At 6718, Mr. Rolfe owns a vacant piece of property. He is the one that actually sold 6716 to Dr. and Mrs. Autry. And then the gentleman at 6720 has written a letter as well in support of the elevator. For me, I believe that's all I have to say. I know that Dr. Autry would like to speak if that's available, please.
All right, and submit those items to the clerk if you would, please, and sign in. Thank you.
Hi, good morning. My name is Steve Autry. This is my wife, Mary Beth. 6716 Surfside Boulevard, Apollo Beach, 33572. We bought this home. We love it. It's a 25-year-old home. It was incredibly run down. We have poured our life savings into this home, restoring it. My wife has some significant medical issues, as I do. We're in our mid-70s. But my wife's condition has deteriorated substantially in the last couple months. She has what we call a polyneuropathy. It's a permanent condition where her legs and her brain don't always work together. So she sometimes has trouble knowing where her feet are when she's walking. It's a bit of a problem even on level ground. In fact, she fell about, 12 days ago, sustained 6 fractured ribs, was in the hospital for 2 days. Can you imagine how difficult it is for her to go up and down stairs? Her life really is at peril when she goes up and down stairs. I have to kind of be behind her, and it's very cautious that she goes up and down the stairs. The elevator is going to be put in a position that the beauty of the home is going to be preserved. It's not going to be anything that if you looked at the home that you wouldn't believe wasn't there to begin with. There's an optimum, an ideal place for the elevator, and we will have to move if we do not get this elevator, because we need the elevator. And I'll let my wife say something.
Hi, Mary Beth Autry, 6716 Surfside Boulevard. This is going to be all about me. I have 2 artificial knees and 2 artificial shoulders. My husband told you about the neuropathy. I fall a lot. When I went down and fractured 6 ribs, it has been the most devastating thing. I really am asking for your help. I'm 73 years old and I sleep on a cot in the study because I can't get upstairs. So when you make a decision, I'd like you to think, how would you want that decision to be made if I was your mother? Thank you.
Thank you. All right, if both of you would please sign in with the clerk. Thank you very much. All right, is there anyone here or online who wishes to speak in support of this variance request? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this variance request? right, do not hear anyone. Development Services, anything further?
No, thank you.
All right. Applicant, did you have anything further?
No, ma'am.
That's a no, thank you. All right, we'll close the hearing on variance 23-0870.
This brings us to section I, special uses. Next item is I1, special use 230605. The applicant is Ian Lieberman, AJI Fowler LLC. The request is a special use for 2 COP alcoholic beverage permit with separation waivers. Staff findings will be provided by Tim Lampkin after presentation by the applicant.
Thank you. Applicant?
Thank you very much. Ian Lieberman, 500 East Kennedy, floor 3, Tampa, Florida, 33602. I'm your neighbor. This application is for on-premise sale of packaged beer and wine, specifically beer at Dave's Hot Chicken, located on Fowler and Bruce B. Downs, for those of you that don't know the address. I am the franchisee and owner of Dave's Hot Chicken, in addition to Fuzzy's Taco Shops here in Tampa Bay. We own and operate 5 Fuzzy's Taco Shops, and this is relevant because I successfully operate and legally operate with 5 4COP SRX licenses, or RX licenses as well. So this process is not new to me, although the brand Dave's Hot Chicken is new to me. The reason for the application is because of the proximity to additional licenses. This is a highly dense commercial zone with a significant restaurant concentration. There's really no consequential residential and/or commercial that would have jeopardized this application with regard to schools, senior homes, really anything that would be somewhat marginalized by our sale of packaged beer. In addition to the reasons on the application for the approval, it's worth noting that this will represent a minuscule piece of our revenue. This is not a bar. This is not even a restaurant with a bar. This is simply providing an additional beverage option for already existing customers that typically only have the option right now to drink bottled soda, fountain soda, or milkshakes. I think that should wrap everything up for me. If you all have any questions for me.
I believe from the application, it's just the number of AB uses within the required distance that you're seeking a variant or a waiver.
Correct.
For.
And the only active license is the Chipotle in our shopping center. In order to, while as the crow flies, there may be some other licenses within proximity, it actually requires significant effort from any potential customer or pedestrian, either on foot or in the car, to either walk down Club Drive and in the rear entry to the much larger center Fowler Commons next door, or they'd be required to walk down Fowler Avenue on the sidewalk, which, as everyone here knows, is taking your life in your hands. Mm-hmm. So this is pretty fully separated from Fowler Commons, which is where the significant density of restaurants are in this market.
Okay. All right. Thank you very much.
All right. Thank you very much. Thank you for your time.
Okay.
Good morning. Tim Lampkin, Development Services, for AB 23-0605. The request is for a distance separation for a 2 COP AB permit to allow the sale of beer and wine for consumption on and off the permitted premises of package sales. The proposed site is located wholly within unincorporated Hillsborough County. However, it is adjacent to the city of Tampa boundary, which is less than 100 feet south of the proposed AB establishment. Staff's findings: the proposed AB establishment is located with an area of multiple commercial establishments of various types, as the applicant has stated, whereby an additional license would not negatively impact neighbors. The shopping plaza is located under 200 feet north of East Fowler Avenue and Club Drive intersection. Additionally, none of the relevant wet zonings within 1,000 feet and within unincorporated Hillsborough County are within the same shopping center. There is a Chipotle Mexican Grill located at 2576 that has an AB license. However, it is in the city of Tampa and not in unincorporated, so it doesn't count as the same classification. The remainder of the AB permits are generally dispersed within the surrounding area, and most are separated from the proposed wet zoning by roadways, vegetation, and other impediments, and therefore have little or no functional relationship. Staff finds that the proposed wet zoning does not pose significant impacts on surrounding land uses, and the necessity for the specified distance requirements are negated. Pursuant to that, staff finds the proposed 2 COP alcohol beverage approvable. Approval is based upon a wet zone survey reflecting a total footprint of 4,626 square feet, as shown on the wet zone survey received on August the 31st, 2023. And that concludes staff's presentation, unless you have any questions.
No questions for you. Thank you.
Thank you.
All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Do not hear anyone. Development Services, anything further?
Nothing further.
Okay, and applicant, anything further? Nothing further, okay. All right, this closes the hearing on special use 23-0605.
The last item on the agenda is item I2, special use 23-0642. The applicant is Christopher J. Kula. The request is a special use for COPX alcoholic beverage permit with separation waivers. I will present staff findings after presentation by the applicant.
All right. Applicant?
Thank you. My name is Chris Chula. I live at 1632 Acadia Harbor Place in Brandon, Florida, 33511. We're proposing a restaurant in Kings Mills Plaza. There's not an established address there. It's a vacant lot right now. We're going to build a restaurant on the premises with a 4COP-X license for foods in association with food sales.
Okay. Is your 4COP for consumption on premises only or also package sales?
There will be some package sales associated with our model.
Okay. All right. And so it's a proposed restaurant, and you're seeking a waiver to, you need distance waiver from community uses and also from residentially zoned property. Is that correct?
Yes, ma'am.
Okay. Can you describe justifications for the waiver?
So we're going to be a community restaurant. Our primary focus is going to be on food sales. We're part of a franchise system that's established that's a community restaurant. During our due diligence period, we did approach the community uses that will be impacted to let them know that we would come to the area. And this is a standard practice of the franchisor. They ask us to always approach so we don't have any concerns with the community. We did approach a daycare that's on the northeast corner adjacent property. And they asked us to submit our business model, which we did, and they felt that we were going to be a good addition to the neighborhood and a good addition to the community. We did also apply for the residential use that is on the northwest corner adjacent to our property to make sure that we wouldn't cause any concern. Our model is going to be very family friendly. There are no shots in our model. There's no excessive consumption of alcohol in our model. It's going to really be a restaurant for family and community use to bring the community together.
Okay. All right. Anything further?
No, ma'am. Thank you.
Thank you. Be sure and sign in with the clerk. All right. Development Services.
Colleen Marshall, Development Services. The applicant stated the request is a distance separation waiver for proposed 4COPX alcoholic beverage permit to allow for sale and consumption of beer, wine, and liquor on the permitted premises. There's also in section 61111C1I, does also allow for some package sales, and it specifies the allowances for eating establishments.
Okay, I think that's what was driving my question, because I did see in the staff report, it says consumption on the permitted premises only, so, but the code allows some package sales, so that I should include that in the consideration, correct?
Yes.
Okay.
Yes.
Thank you.
So let's see. The wet zoning will comprise 3,892.5 square feet of indoor area and 810 square feet of outdoor area for a total of 4,702 square feet of wet zone area. The applicant requests a 370.2-foot waiver to the required 500-foot separation from the community use, the child care center, property to allow a separation of 129.8 feet. A 24.2-foot waiver to the required 250-foot separation from residentially zoned property is also requested to allow a separation of 225.8 feet. The proposed restaurant is separated from the community use by Kings Commercial Court roadway, and the proposed outdoor wet zone area faces toward the west, away from Discovery Point, Kings Mill Child Care entrance. The restaurant building will be located between the outdoor area and the child care center, providing additional screening of the outdoor area. The proposed wet zone area is separated from the residentially zoned property to the northwest by Kings Commercial Court roadway, a 6-foot high PVC fence, and a row of shade trees. Additionally, the route of travel from the proposed wet zoning to the nearest residential property exceeds 500 feet. Staff finds the proposed wet zoning consistent with the mixed-use character of the area, with residential uses in proximity to commercial uses. The existing PD zoning permits both commercial and residential uses. Staff finds the proposed Ford COPX alcoholic beverage permit to be approvable. Happy to answer any questions.
All right, thank you. No further questions for you. All right, is there anyone here or online who wishes to speak in support of this variance request or this special use request? All right, do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this special use request? All right, don't hear anyone. Development Services, anything further?
No, thank you.
All right. Applicant, did you have anything further?
No, ma'am, thank you.
All right, that's a no. So that closes the hearing on special use 23-0642, and that concludes the Land Use Hearing Officer meeting for today.